you have committed to our church. Amen. We have the agenda for the day. We have agenda for the day. You may have a look at it. Number 1, number 2, number 3 minutes. I'm supposed to sign. They are confirmed. Number 4 is consideration of the proposed Kenya School of Law Amendment Bill 2024, sponsored by Honorable Babu, Owino, Member of Parliament. We have a brief on proposed Kenya School of Law Amendment Bill 2024, which is on your folder, which also has an extract of the judgment from the Court of Appeal regarding Otinga versus Cabinet Secretary Agri others, in which the Court of Appeal has made certain observations regarding Section 8(1)(b) of the Council for Legal Education Act and Section 16 of the Kenya School of Law Act. Then after that, we have, we didn't introduce ourselves. Sorry, we forgot. Member of Parliament for the Raka constituency, the chairperson of the Justice and Legal Affairs Committee.
My name is Michael Mushera, MP Rock, member of this committee.
Member of this committee. Yes, that'll be slightly better now, but still a bit loud. Online is Honorable Mwangi Motuse, the Member of Parliament for Kibwezi West, and Honorable Dawood, who has just told me is also on his way. Stephen Magaka is on his way. Otiende Amolo, all these people are joining us, and they are going to join us online. Secretariat.
Clerk to the court. And Kafara Day Clerk Assistant. Member Musoy Anita to the court.
My name is Isaac Abiso, Legal Counsel.
Naibu Clerk Assistant.
Vivian Andega, Research Officer.
Mary Commander, Public Communications Officer.
Carmen Karua, Media Relations Officer.
Nalem Sakani, Audio Officer.
All right. Thank you very much. Yes, Dash is over there. Thank you very much. Honorable Babu, I'll give you a chance to introduce yourself, not now, but as soon as I invite you to make a presentation to us. So let me just brief the members of what we have. After the legal brief, you have a bill. It's just a short bill, and it's not complicated what Babu wants to do. We have the memorandum of objects and reasons. Then we have the second schedule, which is sought to be removed, plus the section 16 of the Kenya School of Law Act, which is said to be amended. And the rest is communication, which is good enough. This is a pre-publication engagement, so that we can make a recommendation to the Speaker as to whether the bill is to be published or not published. So we have not reached the point of public participation, but we will have once a bill for legal education and the Kenya School of Law. But for now, we invite the Honorable Babu Owino to introduce himself, and then we shall give him 10 minutes, which is too long for him just to tell us exactly what he wants to do, and in view of the judgment that has just been pronounced by the coroner here. Honorable Babu Owino.
Thank you very much, Chairman. Good morning, honorable members, and good morning, the Secretariat of the Jailer Committee. I'm Honorable Babu Owino. I have a legislative proposal. Legal Affairs, submissions on the proposed Kenya School of Law Amendment Bill 2024. Honorable Chairman and members, I wish to thank you for according me this opportunity to make submissions on my proposed Kenya School of Law Amendment Bill 2024. Summary of the proposed bill. The proposed bill seeks to amend the Kenya School of Law Act, Cap 16C, to confer upon the Council of Legal Education the power to prescribe admission requirements to courses of study at the Kenya School of Law. And the proposed amendment will, number one, amend Section 16 of the Kenya School of Law Act by deleting the words, and I quote, set out in the second legal education under Section 8, subsection 3A-B-C of the Legal Education Act for that course. Number two, effectively repeal the second schedule of the Kenya School of Law Act 2024, essentially doing away with the admission requirements set out thereunder. Mr. Chairman and members, the background of the proposed bill is that this legislative proposal comes against the backdrop of stringent entry requirements imposed by the Kenya School of Law on aspiring advocates who desire to enroll for the advocates training program offered. Whereas the school has on various occasions argued that the stringent entry requirements are aimed at upholding the quality and competence of legal professionals in the country, these rigorous standards have served to create restrictions to the number of new advocates. These rigorous standards may even be viewed as a way to limit competition in the legal field. One of the reasons put forward by the Kenya School of Law in enforcing strict entry requirements is so as to addressing variations in university admissions for the undergraduate law course. It is indeed true that there have been inconsistencies in admission standards among universities offering law degrees in Kenya. Some institutions have admitted students with lower qualifications, leading to challenges when these graduates seek entry into Kenya School of Law. There is therefore need for the Council of Legal Education to come up with standardized entry requirements that do not disadvantage law graduates. According to the Kenya School of Law Act, admission to the Advocates Training Program requires a valid law degree, a minimum KCSE grade of C+, and a B plain in English or Kiswahili. And this, Mr. Chairman, I find it to be very discriminative. Further, the school does not recognize academic progression for persons who do not meet the minimum entry requirements because the same are not provided for by the Kenya School of Law Act. This is despite the fact that Section 8, subsection 3C of the Legal Education Act allows for recognizing prior learning and experience for legal education progression. This has handicapped many who are stuck in their LLB with their LLB degrees and are unable to proceed to the Kenya School of Law and ultimately become advocates due to unreasonable entry requirements. In light of the above, and in a bid to bring an end to the Kenya School of Law monopoly when it comes to prescribing stringent entry requirements for the ATP program, I deemed it fit to come up with a legislative proposal that will cure this problem. Honorable Chairman, my position at the time of submitting this legislative proposal for consideration and processing was that the question of suitability of a student to join the Advocates Training Program should not be determined by the Kenya School of Law, but by the Council of Legal Education, which is the regulator of legal education in Kenya. Fortunately, the Court of Appeal, in its recent judgment in Civil Appeal number E625 of 2023, delivered on 7th March 2025, resonated with my position. Prior to this decision, any application for admission to the school was considered incompetent, provided it did not meet the prescribed requirements. In my view, Mr. Chairman, this was nothing short of unfair and discriminatory. And this has led, Chairman, we are killing dreams, and I urge this committee not to be part of the process that is going to kill the dreams in this nation, because you may find yourself killing the dream of your own child, Mr. Chairman, or even your grandchild in the foreseeable future, and therefore we need to take it into consideration. Brief highlights of the judgment in Civil Appeal number E625 of 2023, which was filed by Stephen Nikita Otinga versus the Kenya School of Law and the Council of Legal Education and two others. Honorable Chairman and members, this judgment emphasized Council of Legal Education's responsibility to regulate and license multiple institutions for the ATP, that is the Advocates Training Program, ending the Kenya School of Law's exclusive hold on the program. The decision upheld the constitutional principles of fairness, equality, and consumer protection in legal education. Mr. Chairman, this will further provide jobs to Kenyans should we devolve the body that is going to provide this program, to provide jobs to lecturers and support staff. And Chairman, what else do we need if not jobs in this country? And this, in addition, will also earn revenue to our country. The key issues in the case, Chairman, number one, is conflict in legislation. The appellant claimed that Section 16 of the Kenya School of Law Act contradicted Section 8, subsection 3C of the Legal Education Act, which allows for recognizing prior learning and experience for legal education progression. The respondents maintained there was no conflict, and the respondents here are Kenya School of Law and CLE. arguing that both laws served different purposes. Number 2, there was the constitutional principles. The appellant argued that the CLE's failure to establish a regulatory framework for alternative advocate training program providers violated Article 10, rule of law, which talks about the rule of law and legal certainty, and also violated Article 46, which talks about consumer rights of the Constitution. Number 3, licensing of additional legal education providers. The appellant argued that the CLE had failed to create regulations for licensing other institutions to offer the advocate training program, creating a monopoly for the Kenya School of Law. The CLE contended that no institution had applied for such a license, hence no action had been taken. Honorable members, you remember at one point I appeared before you, Chairman, with the same issue before the judgment was out. And Chairman, you will confirm that I was right, because the judges have agreed, the judges did agree with the submissions that I made before you, Chairman, that the advocate training program should not be a preserve of only Kenya School of Law, but should be devolved. The court findings, Chairman, number 1, the court ruled that the Legal Education Act takes precedence over the Kenya School of Law Act, meaning all legal education providers should be subject to the Council of Legal Education regulations. Number 2, the court declared Section 16 of the Kenya School of Law Act unconstitutional and void to the extent that it conflicted with the Legal Education Act. Number 3, the court issued an order of mandamus compelling the Council of Legal Education to develop and publish regulations for advocates training program licensing within 45 days from the date of the ruling. The court found that the Council of Legal Education had indeed failed in its duty to create the necessary regulations for accrediting alternative advocates training program providers. Lastly, the High Court judgment was set aside and the petition was allowed as prayed. Honorable Chairman and members, there are a number of reasons why I strongly propose the strict entry requirements enforced by the Kenya School of Law. Some include, just a few that I'll mention. Number 1, barrier to entry into the legal profession. The stringent requirements created a rigid bottleneck that restricted the number of new advocates, with which some view as a way to limit competition in the legal field. Number 2, overemphasis on grade over competency. Critics such as myself argue that academic grades do not necessarily reflect legal acumen, critical thinking, or ethical reasoning, skills essential for a good advocate. A more holistic assessment approach might therefore be fairer, especially where one has undertaken to progress academically. Number 3, discrimination against otherwise qualified candidates. Prior to the Court of Appeal decision, some students who successfully completed their LLB degree were barred from joining Kenya School of Law due to not meeting the prescribed high school level requirements, even though they already went ahead and proved their competence at the university level. This raises serious fairness issues, especially for those who improved academically later in their education. Number 4, mismatch between university admission and Kenya School of Law requirements. There exists a disconnect between the Commission for University Education criteria for admission into LLB programs and Kenya School of Law's entry rules. Some students who are admitted to LLB programs based on the Commission for University Education Standards may later be blocked from progressing professionally, creating confusion and frustration and room for nefarious and ending court battles between the aggrieved students and the school. And Mr. Chairman, you'll agree with me that this goes against the principle of legitimate expectation. Because why should a university admit a student knowing very well that this student is not going to further pursue his or her dream at the Kenya School of Law? Because you cannot practice law if you are not admitted to the Kenya School of Law. Number 5, disproportionate impact on marginalized communities. Students from undeserved regions or schools with fewer resources stood to be disproportionately affected, even if they subsequently demonstrated capability and dedication in their university studies. This could potentially perpetuate inequality in access to legal education and the legal profession. Number 6, wastage of time, efforts, and resources. Students invest 4 or more years of their lives in their legal education only to be denied the opportunity to qualify as advocates. This results in wasted financial resources, emotional distress, shattered dreams, and delayed or derailed careers. Mr. Chairman, a student who does not qualify to join LLB degree starts from pursuing a certificate course. Then after that, we'll do a diploma for 2 years. Then we'll take another 4 years to pursue a degree course. This student will further, if admitted to the Kenya School of Law, take another 1.5 years. 1 year for the 9 units provided and 6 months for pupillage. Then, Mr. Chairman, this student has studied more than even a medical student. Then you want to tell this student that they cannot be admitted to the bar. They are not qualified to practice as an advocate, which is very unfair. Honorable Chairman and members, it is noteworthy that according to established case law and prior to the Court of Appeal decision, the only academic progression that may have been considered by the Kenya School of Law for the Advocates Training Program in the case of weak KCSE results was a previous training in law and more specifically a diploma in law. In addition, Mr. Chairman, there is an exam that's always offered by the Council of Legal Education, which you must pass all the 9 units. Even if you fail one, you will have to resit. Even if it is 5 times, you will have to do it until you pass it, Chairman, for you to be admitted as an advocate of the High Court. Chairman, I'm talking as a person who sat for my CLE examinations, passed all the 9 units, awaiting admission to the bar in May, June. And Chairman, I know the pain that these students may be going through, having studied for over 4 years at the university, and then looking at their fellow comrades graduating, being admitted to the bar, and them, their dreams are shattered. It's like they never studied at all at the university, Mr. Chairman. This is so disheartening because we know where we come from, Mr. Chairman. These families are very humble. And, Chairman, as I conclude, we need to help these families because these are the lights of their families. A parent had spent everything, including selling all the property, selling everything they had, including animals, doing very odd jobs to educate these students, only not to achieve their dreams. As I conclude, Chairman, I also talk as a person who has lectured the Kenya School of Law in criminal litigation. You can have a privilege to look at the YouTube tutorials. That is Babu Owino lecturing Kenya School of Law. And I think I'm the only lecturer, Chairman, who did a whole unit in 1 hour, 30 minutes, offered without referring. Honorable members, in conclusion, it is my sincere hope that I have been able to convince this committee that this legislative proposal is not only timely, but that it will ensure fairness and objectivity going forward in the admission of persons seeking to pursue the advocates training program. Once again, thank you very much and God bless you.
Thank you very much, Honorable Owino. I think that's an elaborate presentation of the proposal you have to amend the Kenya School of Law Act. But we have a few questions for you. Definitely. Having looked at it, Honorable, would you introduce yourself? Then I can maybe start it off and the rest of the people from there.
Thank you, Chair. I am Adam Daoud, member for the JEs.
That's better now. Slightly better. Yeah, Honorable Owino. Two observations. Number one, I think in view of the decision of the Court of Appeal, your proposal will be well founded now and buttressed by that decision as regards the section 16 of the Kenya School of Law Act. There is a bit of a problem with the pronouncement that that section is unconstitutional. In fact, what it is trying to do is contrary the Constitution, but the Court of Appeal proceeds to tell the Council for Legal Education, to direct the Council for Legal Education within 45 days to make regulations on requirements. My question is, what would happen if the Council for Legal Education reproduced these requirements under Schedule 2, the second schedule, as the minimum entry requirements into the Kenya School of Law? Would this still be unconstitutional? Would it be contra the spirit of Article 10, as was argued before the Court of Appeal? But most important is this: the legal profession is a profession like any other. And in the country, all professions are regulated by minimum university entry qualifications and postgraduate qualifications. The medicals, the doctors, the engineers, even accountants possibly, and everybody else. I don't think there's any that doesn't have some minimum entry requirement. Are we saying that we should be moving away from these requirements, not solely because we now have what is called the competency-based curriculum in our schools, but we thought that was the best way to sieve and get best material qualified for each of these professions? So what are we supposed to do with the medicals, the doctors, the engineers, the accountants, and everybody else? Are we also supposed to move away from this? Thank you.
Thank you, Chairman, and asante sana Dr. Babu Owino. He's a doctor. I'm in support of your proposal because number one, is no, I think it's only law profession among all the careers we have in this country that does not allow for career progression. And we cannot condemn a graduate just because he never scored a degree in English or Kiswahili. So I agree with you totally that we must have a career progression in the law profession, like other professions. If you want to become an accountant, and probably you didn't score the relevant grades, they take you to, you don't go to CPA direct. They take you to something called it used to be called ATC. Now it is ATD. So you start from ATD, you do like 3 years, then you come to CPA and you qualify to be an accountant. And the same applies even to academia. You can start from the certificate level and you become a PhD holder. So we cannot have a career where you hit a dead end just because you didn't score a certain thing. You should have career progression. And number two, in terms of decentralization, because we cannot be telling all the students that you must come to KSL, all the students in the first 7 counties. So I support decentralization of the ATP. We have so many students out there who depressed students, thousands of students who finished their degree. There are thousands of them, but they could not progress to KSL for the training. Let them go to KSL. If they are not able to pass at the KSL level, then that's another story. Thank you.
Yes, thank you. Thank you, Honorable Chair. And I wish to start by saying that the Honorable Babu Owino has very genuine concerns. And I think, Honorable Chair, we need to give a nod to this proposal so that it will be published, so that also we can invite more stakeholders and get to be able to listen to them. Recently, about 2 weeks ago, I met a lawyer who I bet has not yet joined the Kenya School of Law, but who was working as a secretary to one of the lawyers in town. And during that time, when she was working with that wakili, she developed a very keen interest in law and decided to go and pursue law. And she's facing the same challenge the Honorable Babu Owino is talking about. I do not think that we should condemn people just because they didn't get a B plane in languages. There should be an alternative to meeting the requirements. So, you know, sometimes, Honorable Chair, the grade that you got in high school is not a measure of how able you are, because we have met people out here who did not get very good grades but are doing very well in life. Some are even in cabinet, and listening to them, you cannot tell that they scored the grades that are that they are said to have scored. So I think we need to listen to Babu Owino and proceed and listen to more stakeholders so that we can bring to an end to the monopoly at the Kenya School of Law, so that we can actually even offer more people an opportunity to practice law with the necessary qualifications. So, Honorable Chair, I support this proposal.
Honorable David?
Chair, I didn't have the opportunity to hear what President Babu Owino has said. I came a bit late. I just perused through the judgment report of appeal. The judgment just says that KSL and COE CLA to prescribe. So I have no problem if this is just pre-publications scrutiny. I have no problem with language as proposed by Owino. But then I don't have the benefit of seeing what section 83 A, B, C of the Legal Education Act says. So I have seen what section, what the second schedule, section 16 is saying, but I can't see what 83 A, B, C says. What does it say? Does somebody have that?
Why don't you read it out?
Yeah. And we have a problem.
Yeah.
This is.
It says that the approval will never come back here.
Yeah.
We give it to other people. Let us get a place. Yes. Don't bring us to places where we can't talk.
Chair, for me, Section 8 of the Legal Education Act prescribes the functions of the council, which is the CAB. Carrying out its functions under subsection 2, council shall A, make regulations in respect of requirements for the admission of persons seeking enrollment in legal education program. B, establish criteria for recognition and equation of academic qualifications in legal education. And C, formulate a system for recognizing prior learning and experience in law to facilitate progression in legal education from lower level of learning to higher level.
And do we have they done that? They have not. Okay, then I have no problem. Let's wait for it.
Thank you. Honorable Babu? Can we release you?
Chairman, I can answer the questions then.
Are there any questions there?
Yes,
All right, answer them. You asked them, answered themselves.
you asked for there are two observations that you made, and one was a question. That what happens if Council of Legal Education does the same thing? Chairman, it is in the interest of the Council of Legal Education because their own act, the Council of Legal Education Act 2012, states that it is their work to formulate policies. And in case of any contradiction between the Kenya School of Law and the Council of Legal Education Act, then the Council of Legal Education Act prevails. So, Chairman, it is their function to formulate policies that are fair, and as things are, they already support it. It's only that the Kenya School of Law have been opposing. So, therefore, and number two, it is not in their interest to go against the court's decision, which has not been appealed. It is not in their interest to go against it and say that they are going to now declare the judgment that null and void. Secondly, Chairman, you talked about that in every field there are qualifications and they are regulated, which is true, Chairman. Chairman, for somebody to join LLB law degree, there are qualifications. Equally, for somebody to study education or actuarial science or any other course, there are qualifications. There is a minimum, there is a threshold to be met for somebody to attain to study. There is a problem here, Chairman, that in all other courses, there is no problem because majority of the courses, the moment you finish your fourth year, there is no further training. You get to practice, you get to be employed. Even in medicine, after doing 5 years and 1 year of intern, then you are admitted as a doctor automatically, having met the minimum qualifications from high school. What happens to the Kenya School of Law, to the law degree is unique because universities have different qualification threshold for any students to meet. But the problem is that they admit these students. If you don't qualify, you are not admitted as to study for LLB degree. But if you qualify, you are admitted to study for LLB degree direct. But there are other ways of also studying the LLB degree if you don't qualify to do it directly by what we call the academic progression, where You are admitted to the university, but you start at the certificate level. Then after that, do diploma for 2 years. Then after that, you pursue your degree certificate. So the question is, Mr. Chairman, that if the university is aware that the Kenya School of Law will not admit you if you don't have a minimum qualification grade of either B in English or Kiswahili, why would they further still admit you to study law from the certificate level if they know that you're not going to be an advocate? Because that alone brings us back to the principle of legitimate expectation. That the moment I've been admitted to study law under a certificate level, then diploma, then finally degree certificate, psychologically I'm made to know, to understand, either impliedly or expressly, that I'm going to be an advocate after pursuing the Kenya School of Law. Then, Chairman, there's a problem here. That at the Kenya School of Law, there are also qualifications to be met for you to be admitted as an advocate of the High Court. That number one, you must do your privilege for 6 months. And number two, that you must sit for the CLE Council of Legal Education exams. And Chairman, there are 9 units plus privilege 10. So for the 9 units, even if you fail in one, if you get below 50% in one, then you will not be admitted. You have to pass. So therefore, why are they putting that exam again to regulate one's admission to the bar? Then there was introduction of a pre-bar exams before that was done away with. Then why can't that pre-bar exams be reintroduced for such students so that if they pass, then they join the Kenya School of Law? So I think that, and Honorable Mushira supported us. Honorable Karemba said that the grades that you attained in high school might not be a measure of one's intelligence. Chairman, I tend to agree with this because, Chairman, you might have been the best student in your class, but on the day of exams, KCC, God forbid, you become sick. Then you fail. What does that tell about your intelligence? Does it fade away just because you failed in that specific exams? And Chairman, I finished by telling you a short story. That on the day that I was doing KCC biology practicals, at night 2, I was arrested, taken to Central Police Station in Kisumu. And because I was selling chana, Chairman, and I couldn't afford 500 shillings to give the police officers. Then the following day in the morning, because the mentality of some of our officers is that if you tell them that you're in school, they think it's an insult. So, Chairman, it was a problem. It was taken to Central Police Station, locked. In the morning, I started hitting the door of a cell. Then the OCS came, called Mr. Wanyama. He's now retired. He asked me, why are you making noise in the cell? I told him, I have exams now. I have to go and do exams. He asked me, who brought you here? I said, I was arrested while selling chana. Chairman, he offered, he gave a Land Cruiser. He called a driver, drove me to Kisumu Boys High School, which is 5 minutes from Central Police Station in Kisumu. Went to Kisumu Boys, did my biology practicals in home clothes, psychologically so disturbed. By the grace of God, I passed that exam. But Chairman, how many of such are happening? So we cannot use that to condemn somebody. And some of these students scored first class honors having started from the certificate level, did their degrees, got first class honors. So Chairman, do we lose such brilliant brains? And even if yesterday you were not intelligent, today you may decide to work so hard and just pass your exams and don't even sleep and pass your exams. So should we condemn such a student? Otherwise, thank you, Chairman, for the presentation. Thank you, Honorable Karemba. Thank you, Honorable Mushira. Thank you, Honorable Dawood. Thank you, Chairman, and thank you, members of this committee. May God bless you all. I really pray that we have these students. They are outside there in thousands in numbers.
Absolutely.
They have nowhere to go. They will soon become thieves, Chairman, if we don't. You know, they are intellectual people, so they can be a problem to our economy. Asante sana.
But they are lawyers, those are sort of them. Aren't they lawyers?
They can still within the ambit of the law.
They are lawyers, but they are not advocates.
They are lawyers. Yeah.
But no advocates are lawyers.
Yes.
All right. Thank you very much, Babu. And let's revisit that. We'll make a quick decision on it.
addition, there is the clerk of the parliament wrote to the Kenya Law Reform Commission, and there's a decision that they say that they are in support, they are in support, and I read, Kenya Law Reform Commission is in agreement with the proposal to amend the law to transfer the power to prescribe admission requirements from Kenya School of Law to the Council of Legal Education.
We actually have it on.
Asante.
Thank you. Thank you, Babu. But you said you're doing what? School of Law? May, June.
And we admitted
May, June.
as an advocate of the High
Are
Court.
you
So I'll be joining you, Chairman.
That's it. And you taught there when you went to an advocate.
Yes, when I was a student, I was given an opportunity to also lecture. And I did lecture criminal litigation
Very good.
at the Kenya School of Law. Did it for 1 hour, 30 minutes, a whole syllabus.
Who's syllabus?
Chairman, watch it. It's on YouTube.
I will.
Thank you.
But I can hardly remember much of criminal litigation.
That's
Thank
it.
you very much. All the best.